listen, welcome everybody. We are very pleased and happy to have one of the preeminent legal minds in California here ready to go ahead and to present and kind of update us on what's been happening. So, RIG members and others, it is my distinct pleasure to go ahead and to introduce Daniel Bornstein.
But also having to serve the tenant, waiting the requisite period to serve the tenant, seeing if they file a pretrial motion, seeing if they file an answer, setting the case for trial, getting a settlement conference, getting a trial date, all of that time consuming through the process is likely looking at 12 weeks to 16 weeks in Alameda County. And right now it could be even longer because of the continued inertia that we're facing, because of some of the residue of the COVID pandemic rules that are still ensconced within the Alameda County court system. Keep this chart. This is a great chart. If you ever hire an attorney for purposes of going through with an eviction, you can always reference the chart, call up the attorney and say, hey, attorney, where are we in this matter? And with this chart, the attorney could tell you, well, the tenant has not yet filed an answer. The date to file the answer has not yet occurred. We're waiting for it. Once the answer is filed, then we will set the case for trial, and then we will get a settlement conference if a jury trial has been requested and a trial date. The whole goal, of course, is to recover possession of your unit as fast and as cheap as possible, taking into account attorney fees, time, and risk. And when we talk about attorney fees, time, and risk, one of the biggest variables I'm not in control of, which is which attorney they get and how hard they fight. And remember, tenants are going to likely get free representation from nonprofit tenant advocacy groups, and that will likely delay the matter. Good news, as I hope many of you know, the Alameda County moratorium ended as of April, the end of April, and beginning May 1, we largely returned to how we managed landlord-tenant relationships in a pre-pandemic world. However, we also know that some jurisdictions within Alameda County extended their own local moratoriums, and we need to be familiar with it. If you're not a city that has extended the moratorium, we now are done with the COVID moratorium, but we still need to be aware of some of the limitations we face. And I've got to tell you, in the 30 years of practicing law, I have never seen the size of debt that clients are holding in Alameda County, where it is not atypical that a client is emailing me and saying, Daniel, I have $50,000 of unpaid rent debt. Daniel, I have $70,000 of unpaid rent debt. Daniel, my tenant has not paid me for 2 years. I'm about to lose my property. What can I do? This horrific situation is something that I've been dealing with. And of course, I'm empathetic. And of course, I'm sensitive to it. But I have, unfortunately, I am always limited by the law, and there's only so much I can do. The good news is, as this chart suggests, as of May 1st, the Alameda County moratorium is over. Here's what's important for you to know. Rent debt that accrued in the past, we need to compartmentalize it. So for many of my clients who are tangentially familiar with the law, many of you thought, oh, the Alameda moratorium is over. My property's in Fremont. My tenant owes me 12 months of rent. As of May 1st, I'm going to demand all that past due rent in a 3-day notice. Unfortunately, Alameda County specifically indicated that prior to the moratorium being over, you can't demand that rent in a 3-day notice to pay rent or quit. What we are entitled to do at this point in time, assuming your property is not in Berkeley, Oakland, or San Leandro, is we can request and demand the unpaid rent for May of 2023 in a 3-day notice to pay rent or quit. So what we're faced with is the moratorium is over as of the end of April, but we're not entitled to demand that past due debt in a 3-day notice. You could go to small claims court. You could go to superior court. You need to contact an attorney to evaluate when the appropriate time to do so would be and whether it's prudent to do so or not. But you're not entitled to grab in a 3-day notice to pay rent or quit unpaid rent that accrued in January of 2023, in February of 2023, in March of 2023, or any time before then. What we are looking at now is May 2023 rent debt. And if it did not get paid, you can serve a 3-day notice to pay rent or quit. Next week, when June arises, if you've got unpaid rent for May and June, you now can serve a 3-day notice to pay rent or quit for May and June. Hopefully this is clear. It is, of course, for many of you upsetting because you thought when the moratorium was over, you're going to be able to demand that rent in a 3-day notice. You won't be able to do it in Alameda County, unfortunately. Let's look at the sense of finality for you. And Paul, who's a wonderful director, if there's anything you'd like to comment on this, please do so. But what we have learned through lots of lobbying and lots of good public policy is that San Leandro is likely to have the moratorium end July 31st, 2023. With a lot of motivated politicking and motivated landlords putting pressure on San Leandro officials, San Leandro and the incorporated areas will end the moratorium as of July 31st. Oakland's moratorium ends July 15th, with rent being demanded as of August 1st. As I've stated before, Alameda County ended May 1st. August 31st is Berkeley, and San Leandro is July 31st. So with that stated, if you're not in these jurisdictions, Hayward, Fremont, Castro Valley, we are out of limitations and we can proceed in demanding rent, terminating month-to-month tenancies, provided you follow the state rent regulations, state just cause eviction rules, and that's a whole other constraint that you have to follow. Most importantly for you folks, the large Alameda County moratorium is over, and so you're free from that constraint. But if you own property in Oakland, Berkeley, or San Leandro, you're still, in some respects, precluded from proceeding until these dates are over. And remember, when I speak of San Leandro, I'm speaking of the incorporated parts of San Leandro. With that, let's move on. Remember, with the newfound ability to demand rent, do not be over exuberant. You're still going to be faced with having to demand the rent properly. You're going to make sure that you're not making an over demand. If you've got habitability issues that you have not addressed, such as there's no heat, there's an active water leak, the railings to the door, the stairways are loose and dangerous, you could proceed with a 3-day notice to pay rent or quit, but be terribly disappointed when you get to court that you lose your unlawful detainer action. Those defenses are still available. Remember, you have to prepare and serve the 3-day notice correctly. Do not go on Craigslist, do not go online, go to Nolo Press, or pull off a stale notice that you've got in your file cabinet, because you could be serving an improper rent. And remember, which I have repeatedly stated for 30 years, ad infinitum, once a 3-day notice to pay rent or quit expires, and you've decided to proceed with a residential unlawful detainer action, you cannot accept rent during the eviction process, or you will have to start over. You have resurrected the tenancy because you have collected rent when you are seeking to remove the person through the eviction process. Having done hundreds of evictions a year, every year there's always a client who forgets and accepts rent. And I have to inform them that acceptance of rent during the eviction process will tank and impact your eviction lawsuit such that you will have to start over. Most importantly, it's complex. The eviction process is not easy. There are very few owners who are able to do the process correctly from start to finish. The notices are inherently difficult, especially if you're in a jurisdiction that has just cause eviction rules, whether it's Emeryville, Berkeley, Hayward, San Francisco. When I started 17 or 30 years ago, there were 3 eviction ordinances in the Bay Area, Oakland, Berkeley, San Francisco, and now there are like 17 of them. It used to be I had a working knowledge of the 3, but now with 17 ordinances, before I open my mouth, I have to go back to the ordinance and look at it, because most ordinances have the same themes, but the nuances and the rules are a bit different. So you have to be careful, which means for you owners who have units throughout southern Alameda County or throughout the Bay Area, you can't use one notice for all the units, especially if you're in different jurisdictions with different just cause eviction rules. So yes, we are pleased that we're out of the Alameda County moratorium, but we still need to be careful about how to demand rent, when to demand rent, and how to use a proper notice, and make sure your units are in good condition, because a habitability defense is still available to a tenant. If you have an existing code violation on your property, clear it before you're demanding unpaid rent. And I know many of you are thinking, my God, I haven't received rent for 24 months. And now you're asking me to pony up more money to fix my unit before I can demand the rent. And the answer is yes, if it's a habitability issue, because the issue will come back to haunt you during the eviction process, because a clever tenant attorney will demand you rescind the lawsuit because of an existing habitability issue, and you could lose a jury trial if the property is not in good condition. Let's move on. Remember, I have mentioned just about 3 minutes ago that your notices that you pull off the internet or that you pull out of your filing cabinet may be stale and may create a procedural problem for your notices and for your case. So we want you to recognize that if you are not comfortable with handling the preparation and service of termination notices, you want to have an attorney prepare it for you. Or if you have a property management company and that management company has sufficient experience in preparing notices, perfect. But with the confluence of local just cause eviction rules and state just cause eviction rules, I would strongly suggest that any termination notice or rent demand or cure or quit notice that you hope to result in the possibility of a transition of a tenant, that you get a proper drafted notice done by a professional, as opposed to relying on your own old notices or notices that you pulled off the internet. I say this repeatedly, but I will tell you that when clients send me their documents and they email me and say, Daniel, I would very much like you to start the eviction. The notice expired. Here's the lease. Here's the notice. Here's the proof of service. I would say 3 out of 5 times I have to tell the client, I'm sorry, but your notice was either drafted incorrectly, failed to include a proper representation regarding the protections of a particular ordinance, or you did not serve the notice correctly. For instance, a simple procedural error that I see repeatedly made is on a 3-day notice to pay rent or quit, the owner demands not only the unpaid rent, but a late fee as part of the demand. And we know now that in a 3-day notice to pay rent or quit, you can't demand the late fee in the 3-day notice, or the notice is flawed. So that's an easy example of why you want to have someone draft up your notices for you, especially if you're anticipating needing to go to court to recover possession of the premises. All right, let's quickly transition into discussions about geographic dates and rules. While I know this organization is focused on southern Alameda County, I want to quickly go over some of the aspects that some of you may have regarding Berkeley and Oakland. And I want to emphasize that for you folks who have property in San Leandro, who have property in Hayward, you've got to be particularly careful about, in Hayward, the ordinance and just cause eviction protections and drafting up the notice. In San Leandro, we're not getting started with demands for rent through a 3-day notice until after the moratorium is over, which it's scheduled to be over as of July 31st, 2023. Fremont, I'm serving notices and termination notices. Castro Valley, I'm serving notices and termination notices. So in many jurisdictions in southern Alameda, I've started my work. I just have to caution you, on a case-by-case, region-specific basis, there are different rules that you need to be familiar with. Oakland. In Oakland, because the moratorium still is in effect, the only excuse for not proceeding is if we have a health or safety threat at the subject premises and or an Ellis Act. So if you have someone who is engaged in criminal conduct, we can proceed with an eviction, but I am not serving 3-day notices to pay rent or quit or terminating tenancies in Oakland until after July 14th. And one nuance is if you have new construction in Oakland, 10 years or less, the moratorium is not in effect. Originally, we were looking at a longer period of time for the moratorium to remain in effect in Oakland. However, it's now coming to the end July 15th. I will be serving 3-day notices to pay rent or quit commencing August 1st in Oakland, California. I will be serving termination notices compliant with the Just Cause Measure EE in Oakland starting August 1st. Here is a brief chart for Oakland through July 14th. The eviction moratorium, the Oakland moratorium remains in effect. Eviction moratorium and late fee moratorium ends July 15th. Rent increase moratorium ends. However, rent increase moratorium ends. However, the most important thing, and I think I want to correct the rent increase moratorium ends July 1st, but let's make it clear for August 1st, we can demand unpaid rent for August in July, on August 1st. We're not demanding unpaid rent for July in Oakland. Be patient. Many of you are frustrated with many, many months of unpaid rent. And the only thing I can tell you is that, of course, I'm empathetic, but we have to comply with the rules and regulations of the moratorium. And fighting it does not make sense at this point in time, because in fact, the light is at the end of the tunnel and we can see it. To add insult to injury in Oakland, not only did they extend the moratorium, that they also included what I consider to be a pernicious rule that if a tenant owes you $800 and the fair market rent for that unit is $1,969, you're not going to be entitled to demand the $900 or the $800 that hasn't been paid because of new rules and regulations that have been placed in Oakland. The new rules and regulations are as follows: that until the rent debt is the equivalent of the fair market rent on this chart, 1969 for a 1-bedroom, 2,405 for a 2-bedroom, 3,144 for a 3-bedroom. You're not entitled to demand the rent. This is particular to Oakland. So for those of you who don't have property in Oakland, the most important thing is to be thankful that you don't have property in Oakland, because they've made this rule that you can't essentially demand rent under this. A tenant must have a rent debt above that amount for the month or 2 months before you can make that rent demand. Difficult, confusing, probably in contravention of state law, but it hasn't been challenged yet. Every time a new law that is made locally is made, it may take years before the damage is undone. By seeking redress in the courts don't operate quickly. Another burden is that in Oakland, if you have a breach of a lease agreement, you must prove, in order to recover possession of the premises, that the lease violation is reasonable, legal, and substantial before you're entitled to proceed with a successful eviction action. Who's going to determine if the breach is substantial? It's going to be the jury or a judge. So if you have a written lease agreement that is breached, but a judge or jury doesn't believe that that violation is substantial or reasonable, you're out of luck. You can't proceed. Thank you, Oakland Council, for this pernicious rule. Probably not permitted under state law, but it's going to take time, energy, and money to challenge this in the appellate court. Berkeley has extended its eviction moratorium past the local state emergency with the expiration date of August 31st, 2023. The difference, though, is in Berkeley, we are entitled to demand rent for May, but a tenant has the right to assert a COVID impact. And thereafter, if they assert the COVID defense, you're not permitted to file the lawsuit. So I have been serving 3-day notices to pay rent or quit in Berkeley. I've been attaching the COVID notice. And what I'm receiving in response is a statement by a tenant that I still am protected from eviction because I have a COVID impact on my financial status, and therefore you cannot proceed with the eviction. And here's a step-by-step wind down chronologically of the Berkeley process. And most importantly, even behavior that is an imminent threat to life or property, you are still permitted to evict in Berkeley. And remember one thing, we're not going to a Berkeley court. We're not going to an Oakland court. We're going to the Alameda County court system, where all Alameda County cases go to. And the judges have to be familiar with the various nuances of each local ordinance. Question: do you believe the judges in Alameda County are aware of all of these nuances and are going to learn these nuances and rules now? The answer is no. When they get a case, they will be informed of the law, and then they will make a decision about this new information, which means they're not learned in it right now, and they can be prone to the same mistakes that lay practitioners are prone to. Just because a person wears a robe doesn't mean that they're aware and familiar with the law. And that means that with all of these different nuances, we're bound to get poorly decided decisions in court, which means if you can avoid going to court, do so. This is the document that has to be attached to all 3-day notices in Berkeley, which is a document that allows a tenant to assert a COVID-related hardship and between now and the end of August, we're not proceeding with evictions for non-payment rent in Berkeley if the tenant has completed this document. And if you're a tenant and you're served a 3-day notice for May, June, July, or August in Berkeley, the likelihood is with this attached statement, they're likely to sign it, and you're going to have to wait until September 1st to commence your traditional 3-day notices in Berkeley. The good news is if you're in Fremont, if you're in Castro Valley, you're not going to have to wait. You can start the process now. Paul, could Berkeley extend its moratorium? And the answer is it's possible, but not probable. What we're likely looking at, unless there is a emergence of a new COVID strain that causes massive disruption in the Bay Area between now and the end of August, I really do believe that we are looking at the end of this, and that the target date for all of this is for Alameda County, September 1st. That's when Berkeley's will be over. Of course, Oakland's will be over as of July 15th. San Leandro's over the end of July. And so we're in a much better position as long as we're patient over the next 12 to 15 weeks. I want you to know that right now it's time for you to do an inventory of your management and recognize that if you served termination notices while the moratorium, the Alameda moratorium was going on, or you served rent increases during the heart of the pandemic, please contact my office, because if you've done something that's inconsistent with the Alameda moratorium, you better off correcting it now than sweeping it under the rug, because it is going to come back to haunt you if in 6 months you're in the middle of an eviction action for non-payment of rent and a tenant attorney recognizes that your rent demand is improper because you were not permitted to serve a rent increase during the Alameda County moratorium, and you did so anyways. So for all of you, it's time to look at your practices and recognize that if you have a problem, deal with it. And that's, do you have an outstanding notice of violation? Do you have a habitability issue? Do you have a rent increase that should not have been served? Did you serve a rent demand for a 3-day notice that was not prudent? Very easy for me to handle, I would rescind the notice. If it was a rent increase, I may rescind the rent increase, give back the funds, and then do it correctly immediately thereafter. It's a case-by-case basis, but we want to be smart. And remember, tenants have attorneys. They're all bright. They all work hard on behalf of the tenants, and they're looking to zealously represent the tenant's interest, which means if they think they can prevent an eviction because you've made a mistake in drafting a notice or you've got an improper rent increase, they're going to seize hold of that and make it impossible for you to accomplish your goal because you have a technical mistake because of something you did during the moratorium, or because of a notice you used, or because of a failure to correct a violation or a habitability issue. So now is the time to correct it as we trend out of all of the moratoriums and get ourselves into a position of properly handling landlord-tenant disputes as if we were no longer in this COVID pandemic situation. Be advised though, in Alameda County, we're not serving 3-day notices for rent that accrued before May of 2023. We're going forward in time, as we've discussed earlier in this dialogue. Remember, for those of you, you don't need to be a victim of a situation where there's violence in your unit, drug dealing in your unit, vandalism in your unit, domestic violence, tenant-on-tenant violence, criminal activity, fraud, or what have you. Even now, regardless of the jurisdiction, we are handling many different situations where we are able to recover possession of the premises or not. What you do need to remember, and this is something that's lost on many clients, when we allege in a eviction for nuisance or illegal act, where we allege misconduct of this sort, the legal standard is not for criminal conviction, which is beyond a reasonable doubt. The standard in a civil eviction action is by a preponderance of evidence, 51-49, which means that we have a lower threshold to prove the misconduct. I do want credible witnesses. I do want evidence, but if we have people, and this is not atypical, coming in and out of your building at all hours of the day and night, spending 10 minutes in the unit and 10 minutes leaving, and it's a flood of people, that looks like drug dealing is occurring inside your unit, absent an alternative explanation. If you don't have an arrest, that doesn't mean we can't act upon it. So we go and investigate. And if we have witnesses that can say people are coming in and out, and we've seen people leave with small baggies, I'm comfortable proceeding with this, because most of the time, someone who is engaged in drug dealing in your unit, when you call it for what it is, they usually want to move on and find another place to do their business. So we needn't need a conviction. We need good, solid evidence to prove by a preponderance that drug dealing or illegal activity is occurring at the unit. I do want you to know that for those of you who have developments or have other large-scale properties, we do civil restraining orders on behalf of harassing behavior, but it's usually if we need an immediate cessation to the activity. When in doubt, we like to proceed with an eviction action instead of seeking a restraining order, because a restraining order doesn't remove the person from the property. A restraining order restrains the person from engaging in that harassing behavior. You subsequently need to get an eviction in order to permanently remove the person from the property. So depending upon the nature of the disturbance, we either segue immediately to an eviction action, or we may have a hybrid where we get a restraining order immediately issued and also proceed with the eviction process. When in doubt, contact my office. We handle restraining order applications all the time. We defend restraining orders at times when a irrational tenant engages in a campaign of harassment towards management and they seek a restraining order against a manager for no legitimate reason. We will be there to defend your management group and or your employees. Most importantly, you have to realize that as a practicing attorney in landlord-tenant law, over time, I've had to develop a comfort level with civil restraining orders, as well as the American with Disabilities Act and accommodations, because of the preponderance of accommodation requests in a landlord-tenant context. Any of you have listened are well aware that a comfort or service animal is not a pet. And if you have a no pets policy, but someone has a seeing eye dog that helps a blind person circumnavigate space, that's not a pet. That's a service animal, and you are not entitled to deny that person the right to the service animal, or you will face a civil rights violation. Another point that we have to be careful about: we don't discriminate against source of income. So if someone calls you up and says they're applying for your unit, do you take Section 8 or do you take a voucher? My strong recommendation is for all of you to say, please, we welcome all applicants. Submit an application. Do not summarily say we are not taking Section 8 vouchers. There is a gentle person attorney who is suing owners throughout the Bay Area where they summarily reject a Section 8 applicant. It depends upon the jurisdiction, but most importantly, when someone calls you up and asks you, do you accept vouchers or do you participate in Section 8? You simply say, we welcome all applicants. please submit your application, and that will be sufficient to cover you from the risk of being potentially sued for a violation of civil rights. Now, I started off this discussion talking to you about the fact that if you can avoid going to court, do so. And I want to say this. During the pandemic, with the courts closed, we negotiated multiple situations where a tenant voluntarily vacated the premises in exchange for maybe a waiver of rent and the return of the security deposit. These are called buyout agreements or surrender of possession agreements, cash for key agreements. But the most important thing is you're not just giving a tenant money to vacate, you're giving them something in exchange for vacating, and also a contractual agreement that they're giving up all claims arising out of their tenancy, even those claims they don't know about. A properly prepared buyout agreement includes a complete release of claims. So a tenant can't move out and turn around and sue you for a respiratory illness because of mold that they claim existed inside your unit. You need an attorney to draft up these buyout agreements correctly. There's different rules and regulations in different jurisdictions and different protocols to follow. But basically, with the 8 questions answered or information below answered, I can draft up a buyout agreement that's code compliant for your jurisdiction. And I want to emphasize, and I talked to Paul earlier and Sandy, right now in Alameda County, the moratorium for Alameda County is over. We can file a non-payment or rent eviction for Fremont now in the court. Here's the problem. Pre-pandemic, if you filed the lawsuit with the clerk, you'd get both the complaint and the summons given to you immediately, and then you can use the complaint and the summons and serve the defendant the lawsuit. Because of residue with court rules, even this week, I filed a lawsuit for non-payment of rent in Fremont in the Alameda court. They are not issuing the summons yet. So there's still potentially a 30-day delay before I can actually get that lawsuit from the court so I can serve the tenant. So though in the press, it states the moratorium is over, the court is still constrained because of some of the rules that the court has, and they haven't undone certain rules. I can't serve the non-payment of rent eviction in Castro Valley because I haven't been given the summons filed from the court, and I'm waiting on it. So when clients want me to get things done immediately, I can say, I can serve your 3-day notice. It will expire next Thursday. I can file the lawsuit on Friday, but filing the lawsuit and getting the summons back from the court may take 3 or 4 weeks. So we're going to be delayed even more. Hopefully by the end of June, this delay and inertia will be over. But when I say that an eviction process will likely take 120 days, it means that if you talk to a tenant who owes you May rent and maybe April rent, and the tenant says, I'll move out the end of July if you waive the April through July rent, that may be painful, but it may be smart. Because in the end, if you go through the eviction process and you don't get the summons until the middle of June, and the eviction process takes another 120 days and you can't collect the rent, and you're now in October, and then a week before trial, the tenant says, I'll move out the end of November if you waive all the rent, because the cost of a jury trial is more expensive than the amount of rent in dispute, you may very well have to waive all of that rent through October. And you miss the opportunity to do a deal where the tenant would have moved out the end of June or the end of July if you did a buyout agreement. And that's the quick, simple math that you need to be aware of that I can't change. The cost of litigation is a question mark. A deal to have someone move out, at least you cauterized the loss, you've got closure, and we have an agreement that the tenant's moving out and giving up all claims arising out of their tenancy. So I'm a strong proponent of trying to do deals, but with one caveat. In order to do a deal, you have to have a cooperating tenant. If your tenant is not willing to do a deal, if they don't respond to you, they don't respond to emails, they don't respond to phone calls, you show up at the door and you talk to them and all they give you is inertia, then you have to get to an attorney to proceed with the unlawful detainer action. And yet, I always recommend attempts to try to reach a resolution. The one thing you have to remember is this: no one voluntarily makes themselves homeless. A tenant is unlikely to give you a commitment to vacate unless they're confident that they can find another place to go. And so until a tenant finds another place to go, they're unlikely to give you a deal unless it's very attractive and they want to take the risk of moving out by July and they're going to start looking for a place. But for instance, if I'm serving an eviction action and you call me up and you say, I can't understand why the tenant hasn't given up possession of the unit, they're accruing so much debt. And I simply say to them, understood, but they're not going to leave the premises if they don't have an alternative place to go, because people do not voluntarily make themselves homeless. This is the nature of the dispute and at the core of the housing crisis. I have lots of different opinions on the crisis. I have lots of different opinions about public policy, but for this discussion, you have to recognize that we don't really want to proceed with an eviction lawsuit if we can avoid it, because it's expensive, it's time consuming, you're paying an attorney, the likelihood of you ever recovering money is slim. And so the fastest and cheapest way to transition a tenant out, I'm fully in favor of. And that's where we look at buyout agreements. So I have talked for about 47 minutes quickly and expeditiously. I wanted to let you know that it's my privilege and pleasure to always educate you folks about the rules and regulations that you're constrained by. I want to thank you for inviting me and thank you for your attention. I will tell you that we do a lot of marketing and educating through email blasts, and we keep you informed of changes in the law through the email blasts and through social media. So by all means, if you haven't emailed me with your email address, do so, and I'll put you on our email list, because that will allow you to stay informed of the law. The most excellent real estate investors have a working knowledge of the law. They know what they know what they don't know. They know that there are resources out there. They're staying aware and familiar with the changes in the law. And you should congratulate yourself for being a member of this organization and also for attending this webinar, because this is the segue into knowledge, which is going to give you a strategic advantage in managing your landlord-tenant relationships and also looking at investments and understanding what you can do and what you can't do. So with that, I'm going to invite questions if Paul believes that we can do that. And if Paul would ask me any of the questions that have been asked, I'm happy to answer them. And if not, I'll be gracious to answer those questions by email. Most importantly, though, I want to thank you again and make sure you know that I'm available as a resource. I have offices in San Francisco and in Oakland. We have Spanish, Cantonese speaking individuals available to assist. And our whole goal is to accomplish your goal as fast and as cheap as possible, taking into account attorney fees, time, and risk. So with that, I want to thank you very much.
Thanks, Daniel. I've got a couple of questions that we've got from my members. So first of all, I want to thank you.
Paul, I'm sorry, but I can't hear you.
Okay, so first of all, I want to thank you. Actually,
Again, you're not being clear.
I must have some technical difficulties, but is this better? Daniel, I want to just read something out of the chat from our members here. But thank you again for doing this. It was very valuable. One of our members asked, what about security deposits in cable city limits? How to handle before tenant has left the unit?
You know, Paul, I apologize, but I can't hear you well.
Okay, hang on.
That sounds better right there.
Okay.
Okay,
Yeah.
yeah. So again, Daniel,
You went quiet again. Miss Moore sounds louder.
Miss Moore is going to read some questions.
Okay, Daniel, can you hear me?
I hear you better. Yes.
Okay, fantastic. Okay, so we have a few questions. We may not get to them all, so I apologize to our members. We'll go ahead and forward them on email. What about security deposits in Hayward city limits? How to handle before or after tenant left the unit?
I'm always, the security deposit issue is something that I've got to comment upon, which is, I would say 80 to 5 to 90% of owners don't do the security deposit accounting correctly. Remember, a tenant has a right to a pre-move out inspection of the unit, and the tenant has the right to waive that, but you have an obligation to give them that pre-move out inspection before they vacate. You're to provide them notification of what your anticipated deductions will be. And after the tenant vacates, you've got 21 days to do that accounting. And I'm a big believer in being aggressive with the accounting, provided you've got good documentation and you've got good estimates for the repairs that have been done. For those of you who would like, I have a security deposit accounting chart that I'll send to you. And I'll also provide you the move-in, move-out documentation, as well as the security deposit accounting forms that we are using throughout the Bay Area.
Thanks, Daniel. Next one is, when can I collect the past due rent in Hayward? I think there were a couple of people that mentioned they thought they had to wait a year.
It very well may be, and it would depend upon whether we're dealing with the rent control ordinance or not, and just cause eviction ordinance. What I would say is that please reach out to me and give me your unit. Give me whether it's a single family home or multi-unit property, how old the property is, how much debt there is, and then I can provide you that documentation and approach in order to recover those funds.
Okay, perfect. Next one is that you mentioned code violations or habitability issues. How do we inspect the unit to verify the condition? I guess especially if they're having trouble with the tenant letting them in.
Always a age-old problem, which is if a tenant doesn't let you in, you can't know how bad it is in there. I'm pretty vigilant in demanding access. You've got to post a 24-hour notice. It's got to be drafted correctly. If a tenant refuses access after having posted a notice and continues to refuse access, I can terminate the tenancy. And that's expressly permitted under the state just cause eviction ordinance and most other local ordinances. Generally speaking, when I get involved, I'm able to gain access to a unit. I have just completed a court trial where a tenant did not pay the rent, claimed habitability issues, but refused access. And the judge found that that refusal to grant access was a bad faith behavior, and we were entitled to judgment, even though there were some existing conditions inside the unit that were not ideal. The assumption is a tenant is going to cooperate so that they can proceed with a repair. If they don't, contact me immediately, and I will send out a templated letter. I will send out the notice of entry, and I will let the tenant know that if they continue to refuse access, we will terminate the tenancy.
Thank you, Daniel. Are there any rent increase caps to be aware of in Hayward for new construction?
I don't believe so.
Okay. Okay. I think that might,
We've got one more.
okay. Okay. No, that we already asked that one about it being a year to collect. So our ex-tenant in a house in Castro Valley owed us more than $25,000 rent before they moved out, but they own a rental house in a nearby county. In order to put a lien on their house, must we get a court judgment to do that? Since we cannot find their new whereabouts in order to serve a court summons, is there another way that they can put a lien on their house?
There's no other way to put a lien on a person's house unless you have a judgment. $20,000 is a lot of money. I would tell you that if they own a house, we could hire a private investigator. The private investigator could locate where they are. We can file the lawsuit, hopefully serve them the lawsuit. If we can't serve them the lawsuit, I can get a court order to serve the lawsuit by publication. And if ultimately you get a judgment, then we can put a lien on the property.
Very good. Listen, Daniel, again, we want to thank you for making the time to talk to our membership. And just to let our members know, we are always fighting RHA with our civic leaders, going behind the scenes, making sure that your voices are heard. So if we were not able to get to your questions today, please email Daniel Bornstein at www.bornstein.law. It is actually in the bottom of the slide. So we want to thank you again, Daniel.
Sure, my pleasure. And the website is down below. Just quick correction. My email is daniel@bornstein.law. And it's on the slide presentation. And by all means, please share the slide presentation as you would like. And again, it's my privilege to be able to speak with you. So thank you very much.
Yes, and so members, we are going to go ahead and share this on our website. So look for that this week. And again, Daniel, thank you. It was very, very valuable.
Thanks, Daniel.
No problem. My pleasure.
All right.